you, Wissam, and thank you, Wissam, and thank you, everyone. It's great to be presenting to you this morning, your evening. I'm Matthew Smith. I'm the general manager of Southpack Group, and we were established in 1982, and we operate out of the New Zealand, the Cook Islands, and Nevis. And in this presentation today, I'm just going to be running through a whistle-stop tour of those jurisdictions and the products we offer there, why they may be of interest to you and to your clients, and to run through some key features of the legislation, including the tax position. So starting first with that, so that's who we are and where we are. So we are operating in the Cook Islands first and foremost. Now, this was where Southpack established in 1982, and it's where still the majority of our work comes through. And the Cook Islands is best known for its international trust legislation. Now, this was developed in the 1980s out of the 1984 legislation, and its key feature is that it is specialist asset protection trust legislation, and it was developed by Cook Islands practitioners in conjunction with US attorneys looking for ways to make trust structures more protective. So there are key features written into the legislation that provide this protection. And the most important of these is that if assets are placed into a Cook Islands trust before a cause of action has accrued, so before anybody has a reason to be suing you, those assets are going to be protected from any future creditors. So if somebody has a reason to sue you after you've placed those assets into the trust, they are not going to be able to obtain those assets. Even if there is someone with a cause of action that's accrued when you settle the assets, they have 2 years from the date on which you settle those assets to bring proceedings to persuade the court that you place those assets into the trust with a fraudulent intent. And what that involves is that going to the Cook Islands, because foreign judgments are not recognized in the Cook Islands, so it's not enough to get a judgment, say, in the US and then seek to domesticate that. Fresh proceedings must be brought in the Cook Islands, and the creditor has to show to the Cook Islands court beyond reasonable doubt that your principal intent in settling the trust was to defraud that particular creditor, and also that settling the trust left you unable to pay them. There are benefits to Cook Islands Trust beyond asset protection as well. So we see down the bottom of this slide, forced airship laws are not recognised. So if you have a client in a forced airship jurisdiction whose assets will pass a certain way prescribed by law on death, that can be altered by using a Cook Islands Trust, and that allows for testamentary freedom for persons in those jurisdictions. Also, there are no beneficial ownership registers in the Cook Islands. Beneficial ownership registry information, is retained by registered agents, but there's no centralised register and nothing publicly accessible. And in fact, there are strong privacy provisions in place in the law, which make it an offence to, without authorisation, disclose information concerning a Cook Islands International Trust or the persons connected with it. And then down at the bottom here, there are reserved powers for trust settlers, which enable them to, for example, be beneficiaries of trust, be protectors of trusts, and to maintain certain powers over trust funds. So it provides that trusts are not going to be invalid in that situation, although people still need to take care about how they are operating trusts, as though the way in which they are operated could cause them to become invalid if the settler retains too much functional control. And this is just a flow chart which explains how the legislation works. I won't go through it more in detail here, as I appreciate we've not got too long. But this just follows the path down to whether the timeline for a settlement to a trust and the circumstances in which it will be found not to be fraudulent under the legislation and therefore protected from creditors, or whether there still may be a chance for creditors to attached to it. And you'll see from the from this slide in detail, there's a lot of very high hurdles that a creditor needs to clear to be able to access funds placed into a trust. Another feature, a more recent feature of Cook Islands trust law, is the International Relationship Property Trust, which was introduced by legislation in 2021, which is not seen replicated anywhere else. It's unique to the Cook Islands, and the idea behind this kind of trust is that a couple who are in a relationship or who are married can each place assets into a trust, and specified assets are then, if the couple separate or divorce in due course, those assets continue to be held in the trust, and the court can administer those assets, the trustee can administer those assets. What can't happen is that the trust can't be dissolved and the assets sold off to satisfy the divorce proceedings. So this type of trust was developed by practitioners who'd had several years of seeing assets for the benefit of children and further generations placed into trust and then have to be taken out, dissolved and sold off at a fire sale with their value depleted, and they're therefore no longer available for those future beneficiaries. And so it's less about protection from creditors and more about protecting a couple from themselves and from the future state of their relationship. These trusts can also be registered as an international trust as well, so you can have the international relationship property as well as the asset protection provisions available. The other types of product that we deal with in the Cook Islands are set out on this slide. So you've got limited liability companies, international companies, and also Cook Islands has foundations law in place for those less familiar with trust jurisdictions. Limited liability companies offer a flexible company format. There's very limited formalities that need to be adhered to, and they are generally seen as pass-through for tax purposes, and so they're not taxable at Cook Islands law. International companies and limited liability companies can both be used in connection with yacht registration in the Cook Islands, which is a growing industry there. And an important benefit of international companies is that you could also set up an international company to act as the Cook Islands trustee of a Cook Islands trust. So if you run, for example, a family office, you might be based, let's say over in the British Virgin Islands, you're looking to set up a Cook Islands trust, but want to maintain control of that trust for your client, you could do that through setting up a private trustee company in the Cook Islands, and the trust will still be subject to the laws of the Cook Islands in that case. And then this slide just sets out the tax and reporting position in the Cook Islands. So you've got trusts and at the bottom foundations and then limited liability companies, all not taxable within the Cook Islands, with tax generally being attributable to the settlers or the controlling persons of those entities. As far as trusts are concerned, Cook Islands is a signatory to FATCA and CRS, so there is that automatic exchange of information with participating jurisdictions. And that's the case in all the jurisdictions we operate in. The only one of these entities that is subject to Cook Islands tax is the international company, and that is only if it's Cook's tax resident in the Cook Islands, which will be the case only in a limited number of circumstances with those set out there. Moving now to Nevis. Nevis also has an international trust legislation, which is very closely based on that of the Cook Islands, but with a couple of key differences, which are set out here. So the 2-year statute of limitations, which applies in the Cook Islands, is just a 1-year statute in Nevis, and also any proceedings brought in relation to a Nevis trust need to be brought in the Nevis High Court, and a $100,000 bond needs to be paid into the court by the creditor seeking to attack the trust. Other provisions here are as for the Cook Islands International Trust. So again, you've got no foreign judgments and no forced heirship laws, with strong privacy laws in place to protect the identities of settlers and beneficiaries. Really, the flagship product as far as Nevis is concerned is the limited liability company. So this was set up in 1995 as a Nevis product. The legislation was restated a few years ago, and it was one of the earliest jurisdictions to adopt the limited liability company, which, as I mentioned, for the Cook Islands allows that additional flexibility, unlike the traditional limited company structure. What sets Nevis apart is that the limited liability companies there are also protected by the same fraudulent transfer provisions that trust law enjoys. This again is where if nobody has a reason to sue you and you place assets into an LLC, those can be protected from any future creditor claim. If a creditor is able to bring proceedings against an LLC and they are successful in Nevis, the only available remedy to them is to obtain a charging order against a portion of the membership interest of that LLC. But that does not entitle the creditor to force or seek or require distributions from the LLC. They are entitled to a proportion of those if they are made, but if no distributions are made within 3 years, the charging order lapses and it cannot be reinstated, and that is the extent of the remedy available to the creditor. Looking further down, one common use of limited liabilities is as an estate tax blocker. So if a non-US person has assets within the US, those assets would be subject to estate tax in the US on the death of that person. Having those assets owned by a Nevis LLC, which the person owns, breaks that chain, and the assets are no longer subject to estate tax on death. And Nevis LLCs also have the flexibility to be used as private trustee companies. Other products in Nevis are the Nevis Business Corporation. There's very long-standing legislation in place, originally from 1984, around these, and these are a more popular product for people from outside the US who are more familiar with the limited company structure. Still strong protection and privacy available there, and then as the Cook Islands, Nevis also has foundations legislation, but this is they have what's called a multi-form foundation, which can take a number of different forms, but still has the statutory characteristics of a foundation. And Nevis business corporations and foundations can act as private trustee companies of Nevis trusts. And then finally for Nevis, the tax and reporting position there, similar to Cook Islands in that trusts and foundations are not taxable in Nevis, but most likely will be based on the, as far as the controlling person or settlor or beneficial owner is concerned. For Nevis companies, only if tax resident in Nevis, and they are only tax resident in limited circumstances. So if they have a permanent physical office in Nevis or are effectively managed and controlled from there, and there's a simplified tax return that's filed each year to confirm the tax residence of Nevis companies and where their records are held to determine whether they are tax resident in Nevis or not. And then finally, in our sort of whistle-stop tour around the world, we end up back in New Zealand, and the product that Southpac offers from that jurisdiction is the New Zealand Foreign Trust. Now, New Zealand doesn't have the specialist asset protection trust laws that Cook Islands and Nevis has, but there are still strong benefits to a New Zealand Foreign Trust. New Zealand has the strong international reputation, which some clients prefer as a more established jurisdiction than Cook Islands and Nevis. There are still no centralised beneficial ownership registers, and forced heirship laws, like in the other two jurisdictions, are not recognised. New Zealand Foreign Trust can also carry a tax benefit, as if they are settled by a person outside of New Zealand and hold assets outside of New Zealand, those are not subject to New Zealand tax. Although, of course, they may be subject to tax where they're on the settlor or beneficial owner, depending on where they're tax resident. Like the other jurisdictions, New Zealand is a FATCA CRS signatory. and so there is information sharing there, and there is more information that needs to be submitted to the New Zealand regulator, to the government, on New Zealand trusts. So there is information about trust assets, contributions, and distributions, as well as the identities of all persons involved, needs to be provided, and so there is less in the way of privacy available, but still a good protected product, and one that receives a lot of interest from around the world. And our tour is over. Thank you very much, everyone, for listening. Happy to answer any questions that anyone has. And that is who we are and where we are. Thank you.
Actually, Matthew, can you go back to this last slide before the one before this?
Yep.
And in the one before this one, you were talking about there is no UBO register.
Yes.
And how is it
Yes.
how is it that they apply the CRS, an automatic exchange of information, in the absence of this register?
Because it's the trustee company that provides the information for sharing. So it is not done by the government from a register. That information is provided and then shared by the tax authorities. It's just not picked up from a centralised register. But there is sharing of that information with government as part of that process.
And I have a second question.
Yep.
So you would say, argumentatively speaking, that the US is the biggest client, US persons are the biggest clients you have using these
It depends. Yeah, it depends on the trustee company. For us, the US is our biggest market. That's the market that the asset protection product was set up in mind, because the Americans are particularly good at suing each other. But they have worldwide application. I know other trustee companies have a lot of clients from China and the Far East, for example.
Okay. So it's gaining popularity, what you would say. What about other countries like the Middle East or Europe?
Absolutely. I mean, you've got asset protection is useful for everyone, and you've got the privacy benefits, the forced heirship benefits. So it is a product that has worldwide appeal. I believe it's just sort of not as much picked up in those other jurisdictions. I think a lot of European clients work with some other trustee companies. We have an increasing focus there, but still a very US weighted ourselves.
Okay.
But we're trying to change that.
Yeah.
I have a question. Do you have any experience
Yes.
if German companies using your jurisdiction? Because I don't think that the German financial authorities would accept it.
Right. What would they sort of not accept about the
Uh,
jurisdiction?
German authorities, financial authorities, don't in anywhere in the world accept the concept of a trust system. And if the beneficial owner
Okay.
is not there, and if it's tax
Yeah.
heaven, then any payments to there is not accepted as a.
Right, I see. I mean, the legislation in Cook Islands and Nevis certainly is drafted to state that a trust will be valid regardless of whether it's recognised as a legal construct in the jurisdiction of the settler. So it would still be a valid trust. But from a tax reporting perspective, if you have a settler who's placed assets into the trust, they will generally be taxable in their own country. So for German clients, perhaps just to sort of resolve any difficulties there, a foundation may be a preferable option.
Yeah, yeah, okay.
And
I,
foundation still, yep.
yes, I have a question also regarding this, because indeed in Europe, trusts are not looked really favorable, and generally when paying, I would say, interest or anything, they are not deductible. I understand
Yep.
clearly that's really an asset protection tool for individuals, just to protect really their assets, not for tax purposes. But looking to the CRS and no beneficial ownership, through the CRS, who's the declared as the benefit, not the beneficial owner, but who is declared to receive the interest of these assets, or at least revenue, because it's tax transparent. So the tax should be indeed taxed at the level of the founders or the trust. I don't know, not the trustee, but the trustee is just to protect the assets of the founder.
Yep. Yes, so it will depend how the trust is set up, for example. So most of the trusts that we manage are for protective purposes. They're actually set up as fully discretionary trusts. So there's no automatic payment of interest to beneficiaries, for example, and distributions aren't happening regularly. They're sort of happening on request and if appropriate. So in that situation, from one year to the next, you actually may not get any. There may not be FATCA or CRS reporting, depending on the assets held by the trust and whether there are any distributions. So if, for example, a trust holds company interests and there's no distribution that takes place in any year, there's not going to be any FATCA or CRS reporting for that year. If it holds a bank account, then and there's interest in the bank account that remains held by the trust, there would be some FATCA CRS reporting, but there wouldn't have been a taxable distribution, for example. Generally, the settlers or the founders are regarded as the beneficial owners, or if there's a different person who's a beneficiary and they receive a distribution, then they would be as well, and they'd be reporting on that person.
Okay, so revenue realized through the assets of the trust, even not distributed, will be declared through the CRS to be taxed in the result period.
If it is if it's held directly by the trust, then the trustee would CRS report on that. I mean, if it's held by a bank account that's held by an underlying company, for example, it would be the bank that's doing that reporting rather than the trustee. Yes, it would then just depend on the tax laws where the settler is resident, whether, for example, any trust income received in a trust bank account is attributable to that settler for tax purposes. So obviously everyone's different when it comes to that.
Okay, thank you.
Any other questions?
Hi, just a comment to thanks Matthew for presentation. I'm calling from Portugal, and the companies here used to use the trust in Gibraltar and Malta, so countries close. But again, yeah, thank you, Matthew, for your presentation.
No, it's a pleasure, and thank you very much. Sorry, I feel I may have run over the 12 minutes. I'm sorry, but thank you.
It's fine.
Shall I stop sharing with Sam?
Yeah, thanks. I'll stop recording.
Okay.